Hello, everyone. Welcome to our webisode on New York State reopening guidelines, HR, and legal implications. When we scheduled this session, we did not have the green light to open, so it's fortuitous that we're doing it on the first day that the phase 1 reopening can begin. I am extremely pleased and honored to have some incredible talent on with us today. Liz Warren, the Executive Vice President and Chief People Officer at Employer Services Corporation, and our board member and longtime friend, Ann Nabanco, member and chair of the Labor and Employment and Law Group from Hurwitz and Fine, and Joseph Brown, who's also a member of that group. So the format today is really what we see that has worked, which is what are the questions that we are getting from all of you about what this reopening means. And we thought, instead of just talking to you about how to put together a plan, there's a lot of guidance on that. We really wanted to focus on sort of the deeper, what's underneath that plan and what are the HR and legal implications for you as an employer as you begin to reopen. So for all of you, if you have a question, you can submit it through the Q&A. And I would suggest if you see a question listed there that is similar to the one you want to ask, like it, because the questions that have the most likes will get answered first. It's upvoting things. So we're addressing the concerns of people as best we can. And I would just say that any questions that we don't get to during the session, we will respond. Our BizLink team will respond to your questions. So every question will get answered. So, but hopefully we won't have that many because you guys have put together a really fantastic list of questions. So let's start. And so let's get to the first question, Kath. The first question is, well, where do we start when we reopen? What should we consider? What type of plan do we need? And how do I communicate this to employees? Liz, you want to walk us through that?
Certainly. Good morning, everyone. And Dottie, thank you for inviting me. I think this is, as you said, timing is perfect. And this is a big question. What do we do? You may be already open as an essential business. You may be in phase 1 and just starting to open as of this week, or it may be coming for you in the next upcoming weeks. So one of the most important things that you really need to think about is your plan should be both people and physical location focused. So the people side of things is very important. You really need to think about who are you going to bring back when? Are you bringing back everyone at once? Do you want to do a phased in approach? Those are the types of things that you need to consider. And you need to think about having those conversations with your employees. And we'll probably talk later, I'm sure a question will come up regarding what about employees who choose not to come back and how do you handle that? So you do want to have a written plan. I think you've probably all looked at, forward.ny.gov, and you can use that as your template, but you really want to consider what are you going to do to your physical environment. I would walk your physical environment. You may want to have a risk assessment done by a consultant that they're not expensive, and they will really give you a focus. Maybe you need to put up plexiglass. Maybe you need to sit people in every other cube, depending on how close your cubes are together. Maybe you're on a manufacturing floor and you need to change your process a bit. You need to think about all of those things. And then you need to think about the people, have a plan, a written plan, documented, and then decide how you're going to communicate that to employees. Just like this, just like today, what we're doing, a Zoom meeting is a perfect way to communicate to your employees about what your plan is. And I would say my best advice is over communicate. Your employees will have lots of questions. Some of them will have fear. Some of them will be, so excited to come back. They can't wait to walk through your door. But these are all of the things that you need to consider.
Thank you, Liz. I would just add that we're talking to a number of industry leaders, particularly those that are essential businesses that have put in safety plans in place. That does not mean that you don't need to put together the plan that the state has asked you to put together. You need to, and my suggestion would be to audit your own plan to make sure it conforms. But even if it does, you still have to sign. There's a testimony that you have to sign that's on the website as well. So that's an important step as we begin reopening. So our second question is one I hear a lot, and Joe and Anna, if you would take this, is COVID testing allowed? What about temperature checks? What do you suggest for testing?
Hi, good morning, everyone. Joe Brown from Hurwitz and Fine, and thank you for having us here today. Just got to do my one lawyerly thing and say that we're not giving attorney advice today. We're just providing some general information. The other thing that you probably have figured out following all of this is that this information is rapidly evolving. So while we're presenting on the best known information, the regulations change on a daily basis. I don't know how many times I've drafted an employment alert only to say, oh, I got to go back and add this because it just broke today. So one of the big challenges is trying to keep up with all of the regulations and guidelines that come out. But getting onto this issue of testing, before answering those questions, I would note that neither the federal or state interim guidance mandated employers conduct a certain type of test. There's certain minimum screening requirements, but with that said, if you're going to conduct some tests, you're going to have to be mindful of guidance that's been issued by the EEOC, CDC, as well as New York interim testing. So the first question is COVID testing allowed? And the answer to that question from the EEOC is yes. They weighed in with some questions and answers about the Americans with Disabilities Act. And so diagnostic testing is permissible during this pandemic. But employers should ensure that those tests are accurate and reliable based on guidance from the CDC and FDA.
Hey, Joe, can I interrupt you on this question?
Yes.
Because we know that for people who are listening, that the county, both in Erie and Niagara County, they have free diagnostic testing. And it doesn't cost anything to the person taking the test or to the employer. And all you have to do is make an appointment. But the test results, so let's say an employer says, go get tested. Test results go back to the individual. So if someone, not to the business. So talk about that. Can you compel, if you send someone as an employer to go get a COVID test, can you compel them to tell you the results of that? Is that allowed?
I believe that is allowed under the current guidance. It also depends on what type of testing it is. If it's a diagnostic test, that's one thing. What's not clear from the EEOC guidance is what about an antibody test? The EEOC guidelines don't speak to an antibody test. So therefore, at this moment, it's unclear whether or not that type of testing you would be allowed to ask employees about. And then there are also questions too about the reliability of antibody testing that's continuing to evolve. So at this point, I think for that type of testing, I think it's uncertain. And if I was advising a company, it would be to shy away from requesting that type of information until we have further guidance either from the state or the CDC and EOC about whether or not that would be appropriate.
Okay, great.
And I would just say, I don't know, Anne or Liz, if you have any additional insights about that type of testing, but that's, I guess, based on my understanding of what the EOC regulations currently state.
Well, and clearly the temperature checks are acceptable.
We've actually created a kind of health screening form for our clients to utilize that we'd be happy to share with you, Dottie, so that you could share with the membership if anyone is interested in having that. As the latest guidance says, we need to screen people every day, which seems to be very burdensome. But we'd be happy to share that document.
That would be great. And I will tell you on temperature checks, as everyone who's listening to this probably understands, you could be asymptomatic and transmitting virus and not have a temperature. So relying on temperature checks is not enough, quite honestly.
Mm-hmm.
And, but the next question, which is a really good question, is can employers maintain a log of their employees' temperatures? And before you answer, I think Joe and Ann, you're going to answer this one. We have been having a listening tour with the Lieutenant Governor, industry specific for every industry. And her guidance to all of these industries is to document everything that you do. Because as you may know, New York State nor the federal government has passed any sort of freedom from liability for people who are doing everything that they should be doing. And Partnership is advocating with other organizations in the state to make that happen. But her current guidance to all of those people listening is make sure your documentation is up to snuff. So I'm really interested in your answer to this question about can in fact employers keep that log?
And I think this is a good question because it highlights some of the differences that we're seeing between the EEOC regulations on the one hand and also what the state guidance says. So the EEOC answered this question on April 9th. They said, may an employer maintain a log of the results? And they said, yes, the employer can do that, but they need to maintain the confidentiality. But more recently, when this interim guidance came out from New York State, it says the responsible parties are prohibited from keeping records of employee health data, e.g. temperature data. So the rule is you can screen employees for temperature, but I don't think you should maintain the actual temperature. You know, John Smith, temperature was 99 degrees today. So the way at least I've been setting up forms is that you can, one of the questions can be, has the employee have a fever above 100.4, but not record the employee's actual temperature. So this is just another example of where you really have to be mindful of the distinctions between what the federal guidance might say on the one hand and what more recent state guidance says.
Yeah, and I think this is to me this is where this starts to get really ugly, okay? Because so an employer needs to be able to prove that they have carried out their safety plan, right? So just to not be able to document that they're doing it is, or I guess I have to find some anonymous way of documenting that they're doing it. That would seem to me that leaves them a little bit open from a liability point of view. I don't.
Yeah, well, I think you can still document it. You just have to be very careful about how you document it.
Okay.
So in this instance, not recording the actual temperature and keeping a log of it, but you can record the fact that the employee was screened and they reported that they had a temperature below 100.4.
So let's say from a documentation point of view, you could, Joe Smith can certify his temperature was taken, but you don't record what the temperature is?
Right.
Okay.
The question, the inquiry being, was it above 100.4? Do they have a fever or not?
That's great. That's really good guidance.
Yeah.
That's
and the other thing to note too, just quickly before you move on to the next question, is that the EEOC has issued some guidelines about confidentiality about how you should store that information. So I won't get into all the details, but you can find that at the EEOC's website.
Hey, Joe, do me a favor. Will you send us the link to that? Because we'll send something out after this webinar, recording of it, and we'll send those links with that as well, if you don't mind. That would be,
yeah, we can do that.
That would be super helpful. Okay, great.
The CDC also has some really specific advice. If you as the employer are going to take temperatures and you haven't hired an outside nurse or medical assistant to do so, there's some really specific things you need to do that the CDC is saying, with wearing face masks and really plastic guards and things such as that, above and beyond what would be typical. So I can send you that link as well.
That would be great. We have a number of manufacturing members who have actually outsourced to nursing groups to do that, and we have a list of those vendors that are willing to do that as well. And again, protecting them from liability, but also not wanting to make their staff uncomfortable doing something that they may not be qualified to do. So we'll make sure we get that out as well. That's great. Thank you for that dialogue. Okay, question number 4. What if an employee who was laid off refuses to come back when I recall him or her? Is there a difference if they state they're afraid versus they want the extra $600 in unemployment benefits? Who's taking this one? This is Liz.
I definitely have handled this probably several times, more than several times over the last several weeks as people are starting to call people back. So we're seeing all kinds of different reasons why an employee may say they don't want to come back. And there is a difference. If they don't want to come back because perhaps they have
Oh, Liz, we can't hear you. Oh, okay. Liz, you're frozen. Joe or Ann, can you take this, or you want me
Sure.
to take it, or?
Well,
Yeah, I go ahead, Ann.
I'll just jump in. Joe can follow.
there is a difference.
There is a difference. Oh, are you back?
You're back. We lost you. It was like you were frozen in time there for a second.
Okay, sorry about that.
That's okay.
I was still talking, so hopefully, I don't know, did you hear me?
We
or
didn't
not?
hear you, or we didn't hear you. Nothing. We got nothing.
Okay, so I will start over. So we have had definitely many instances where employees have been called back over the last few weeks, and we have heard this. So we've heard people enthusiastic to come back. We've also had people say, I don't want to come back because I am earning more to stay home than if I would come back to the workplace. So what I was saying is it is very different that if someone says that I don't want to come back because I'm earning more versus someone who says, you know, I don't have the child care to come back because my daycare center, school is closed, or I have an underlying condition that doesn't, you know, that is giving me fear to come back. So all these circumstances do need to be handled individually.
Yeah, and I will tell you, we had the Department of Labor, head of the local Department of Labor, on a call recently, and this is the issue for a lot of employers. And she was very clear that if you are called back to work, absent the child care exclusion, and of course your own medical situation, that an employer has a right to bring that person back, and if they refuse to come back, they technically are not eligible for unemployment. But in order for that to be effective, an effective strategy to get people to come back to work, employers have very specific documentation in terms of notice that they have to do. And we're actually going to do a webinar on this very subject about what employers need to do and how they need to protect themselves in this, because we need people to go back to work. I mean, you know, these businesses can't open without their people. And so anyway, which leads us to question number 5, which I probably already kind of semi-answered here. I apologize. Can their employment benefits be stopped if they refuse to return, and what are the best practices? So Liz, I took away a little of your thunder there. I apologize.
Oh, no worries. I think that for sure, yes, as you said, that they can be taken away. And what we recommend is an offer letter being emailed to that employee. So you have in writing, here, we want you to come back. We're recalling you from your furlough or from your layoff. You're coming back to the same job. Document what that job title is, what their rate of pay is. And if they refuse that, we would suggest a refusal form so that you can submit that to the DOL, and they're not ready, willing, and able to work, which would absolutely disqualify them for certain.
Okay, and we touched on this. Does you guys, Joe?
I was going to say,
I
wanted to add one more thing. And this has actually come up with respect to the guidance on the Paycheck Protection Program too, where the SBA has issued a question and answer dealing with this question about if an employee refuses an offer to rehire. And the thing they also recommend is that you have a good faith written offer that is for the same pay and same hours, and that you document the employee's rejection for that offer. So that's just another reason for you to make sure you have adequate documentation, because that may tie into your PPP forgiveness issues and how you're complying with that.
But Joe, I think with the PPP, it's not if the same person comes back, it's that you have a body, right? Isn't it? It's a number of FTEs you have.
It's a body. It's a warm body. Mm-hmm.
Yeah, because people get confused about that. They're like, if this person doesn't come back, then I'm, my PPP loan. No, as long as you have a body that you've hired that's doing that job, you're technically, that won't impact your PPP, but you got to get that body to take the job, right?
the SBA absolutely recommends to document a refusal to return, and that will help ultimately in the analysis of PPP forgiveness.
Liz, do you have a sample of a refusal document that we could share with our attendees today? That would be awesome also.
Yes, I can send that to you.
So we touched on this next question a little bit, Liz, but maybe we can go in. This is a sticking point. What if an employee states they cannot come back because they have school-aged children at home?
Yeah, so this falls under the Families First Act on the federal level, and you really have to think about a little bit. There's been some clarification about age, and it's been stated 14 years or older. You know, most likely you can get them to come back to work because the children can take care of themselves. But if they have younger children at home, it will depend on whether they can perform their job remotely or not. So if they can perform the job remotely, they won't qualify for that leave. And there's a lot of confusion that I hear from clients and just the general public about that. So it's really important, if they can perform their job at home, you need to let them remain at home and perform their job. I've even read some articles that say the federal government understands that person will be a little bit less efficient than they would be if they were just sitting at home on their own, but that's something that you as a business have to accommodate. So it is important. Now, if they can't perform their job at home, there's plenty of people who can't do that, then they would most likely qualify, depending on the size of the organization and so forth, for that leave. So that might be something that you would want to talk to your HR department or an HR professional about to determine if that person does qualify for that 12-week. That's Emergency Family Medical Leave Expansion Act that falls under that category.
Thank you, Liz. Question 7 is, we have employees with underlying medical conditions that could create a higher risk of a person developing a severe illness from COVID. What should we do if an employee with an underlying medical condition requests an accommodation? And can we exclude those employees from returning to work?
Now I have an opportunity of saying hello to everybody. Good morning. I'm Anna Benko. I'm just jumping in here. These are really important questions. And I think the first thing that employers need to understand is that they cannot project their own concern over an individual. So supposing you have an employee who has, let's say, a pregnancy, maybe it's a high-risk pregnancy. Can you go to that person and say, I'm not going to have you return to the work because I think that the work environment is too risky for you? And the answer is no. Of course, you can't go to them and do that. They have to come to you and say, I have a medical condition and I am requesting a reasonable accommodation. And what does that do? That triggers a dialogue that the employer must engage in with the employee to determine, do they have actually an appropriate medical condition? A lot of people, by the way, think COVID-19 is a protected medical condition under ADA, and in reality it's not. It's not one of those disabling conditions. So the key takeaway is to make sure if someone is asking for some kind of accommodation, they don't need to use the word reasonable accommodation. They can just say, I need to have a change in my job. You have to sit down with that person. You can do it interactively, you can do it on the phone, you can do it by email, but you must have this conversation with the employee to determine whether or not they have that qualifying condition and whether or not a reasonable accommodation can be created. And once you have that, then you can certainly move to create that reasonable accommodation. The worst thing you can do is ignore the request. That's absolutely where you're seeing liability exposure in today's workplace. So engage, document those conversations. I usually recommend to the employer that they have more than one conversation. A lot of times there's a medical note from the medical provider that says, this particular person has XYZ and they are going to need this kind of protective equipment. They need an N95 mask. They need a backup mask, something given their condition. And you always try to meet whatever the medical recommendation is and what the employee is looking for. But ultimately, it's up to the employer to decide whether or not they can make that accommodation, how soon they can implement it, and then you have to communicate that decision to the employee. So just remember that documenting that interactive conversation is going to mean a great deal if there is a claim that you did not provide for a reasonable accommodation.
So Anne, what if there isn't a way to provide a reasonable accommodation, based on whatever the job is? Do you know what I'm saying? I mean,
Yes.
So what happens then?
Well, you have no obligation, but the burden is on the employer to prove that they cannot provide a reasonable accommodation to allow that person to perform the essential functions of the job. So I would work really, really hard to try to come up with something to accommodate that individual. Otherwise, you are relying on an undue burden defense, or a defense that says we cannot, nothing will work, and we cannot accommodate this, and therefore we are not going to be able to have you return to the workforce. So being flexible is important, trying to find creative opportunities for the individual to come into work, maybe even restructuring some of the job description that that person has without impairing the essential functions of that particular position. Again, I think Liz started this whole conversation with communication is so important, and it is important. And we find that the more you communicate and you try to work with the employee, the fewer problems you have down the road, because then the employee knows you're trying to work with them. But when you ignore them, that is a sure sign of creating discontent in the workplace and liability exposure.
That's really good advice. I'll share with you, on one of the industry calls we had this week, there was a small restaurant owner who had a person who had complicated medical history and was at high risk, but really wanted to come back to work. So she arranged for that person to come in first and do her work before anyone else comes into the building, and she leaves before they come. She does food prep, and changed the whole layout of their staffing for the whole restaurant in order to accommodate that, because it was a good employee and she really wanted her to come back to work, and she really wanted to come back to work. So
well, and that shows creativity,
exactly,
and flexibility.
Absolutely. So we're about halfway through our prepared questions here, and we have quite 23 questions on the Q&A, which we will never get through. So if you would go and look at that Q&A and vote for the question that looks most like the one you want to ask, hopefully we'll have some time, and we'll try to get through these last few questions quickly so we can get to some of the specifics. So question number 8 here is, what if an employee returns to work, but after he returns, he decides he's not comfortable with returning to work? Can I require these employees to return to work? Can I allow them to telework while making other employees return to the workplace? And Joanne, this is for you.
Well, this is very similar, but somewhat different than the prior question. And that is, somebody returns to work. Now, all of a sudden, they're not comfortable. What do? As an employer, you talk to that employee, find out why they are uncomfortable, because you might find out something really interesting, do something about it, and protect yourself down the road. OSHA is a good example. So if an employee returns to work and all of a sudden looks around and sees that no one's wearing masks and no one's got any appropriate protective equipment that may be necessary given the particular manufacturing facility or employer that you have, and all of a sudden they see that they are not safe in the workplace. So if they're telling you they're not safe because of a certain condition. Maybe it's the disinfecting that's not being done properly. Maybe that it's allowing people to come in when they're coughing and sneezing and not well. Finding that out first is very, very important, because then you can take steps to modify the workplace, get it up to proper safety standards, and that way you're meeting the employees' needs for a proper workplace, and you're satisfying OSHA in case OSHA is there to inspect. And for those of you that are very concerned about workplace safety, OSHA just came out with new guidance yesterday, so we will send you that link as well on the OSHA guidance, because they are now stepping up their personal inspections, which they had said less than, I don't know, 3 weeks ago that they were not going to be doing that. So that's a big change. You have to be ready for it. Otherwise, you might have an OSHA violation.
So can you require them to return to work, Ann? Can you require them to return to work?
Well, again, that's where a reasonable accommodation discussion might be appropriate, because if they come back to work and all of a sudden they don't feel comfortable given their underlying medical condition, which you didn't know about, then you are going to have to engage in that reasonable accommodation.
So, but and practically speaking, let's say someone doesn't have a medical condition. They're just, paranoid. Okay. So, and that's legitimate. Fear is legitimate, obviously. But, and the last question on this is how do I allow this and then other people in the workplace?
Right.
So, I mean, I think we all understand if someone's got underlying medical conditions and we got to make reasonable accommodations, but how do you deal with this issue of, I just don't feel comfortable because I'm nervous?
Not feeling comfortable, it's not a safety issue, it's not reasonable accommodation. Fear is not enough. Just because you fear contracting COVID-19 and you're not comfortable in the workplace or working around other people, it's just simply not enough to satisfy a reason to make an accommodation for that person. Now, you could, but then you have to make sure that as you make an accommodation for someone who does not have an underlying medical condition or some other justifiable safety reason, you have to be sure that you can apply that consistently with all the other employees. Because if not, you may end up with an inadvertent discrimination claim. So, but again, talking with the employee, trying to reassure the employee that they are in a safe environment is, I think, the initial threshold after the reasonable accommodation analysis that you need to make sure that it's a comfortable place to work. But otherwise, you can simply say, all right, you got paid time off, you've got 2 weeks accrued, take that time and be home. But you don't have to allow that person to manipulate, as they often do, the employer's decisions.
I will say in the calls that we've had with industry people that the employers that are having the best success, let's say, is making sure that it's very visible what they're doing for safety with their employees, and they're really communicative, as Liz mentioned,
Right.
and even the temperature checks. Most of them understand it really doesn't. It does prevent someone who's really ill from walking in, but it's not enough. They understand that, but they also understand that in order to make their employees feel like they're doing everything that they can do to keep the workplace safe is really half the battle. So there is an onus on employers to do everything that they can. So let's move on to question 9, because we've got quite a few folks listening. Should I allow visitors to my workplace? If yes, can I screen them for illness? Liz.
That's really an individual question, and a lot of it depends upon your industry and your company, and are your visitors your customers, or are they just people coming into the workplace? So most clients that I'm working with are making a determination June 1st how they're going to handle that, giving it a few weeks to see how things go. Right now, most even essential businesses are not having visitors come into their workplace. I think it's a good idea to be a bit conservative on this side. It also helps you from the employee side. If you limit visitors, maybe you limit them to a certain part of the building as well. That can be important. And you absolutely can screen them. Along with that health screening that we have for employees, we also have one for visitors where they're just, quickly checking information that they haven't, been to any area traveling in the last 14 days and they don't have a fever and they don't have a cough and those types of questions. So I think that it is important to screen visitors, and that's another form that we can send along to you if you would like.
So Liz, this question isn't exactly related, but from the group, it's got 23 votes up, and I think it does relate. It says, are face coverings, masks required for private businesses not open to the public? Do you know the answer to that question?
I believe I do. Okay. And it's a question I'm getting every day. So it's been pretty clear that face coverings are necessary if you're out in public. And you can't maintain 6 feet of distance if you're going to a retail store, as an example. But I've seen nothing, and certainly Ann and Joe, jump in if you've seen something different, but I've seen nothing that says in a private company, when you can maintain social distance, that you need to wear a mask. Right. And in fact, I've had a risk assessor tell me that that is not necessary either. Now, if you're in close quarters and you can't maintain your 6 foot distance, then you should wear a mask. But otherwise, I do not think that they are necessary.
Okay, great. Let's go on to question 10 here. What if someone who has already returned to work notifies me that they are COVID positive? What steps do I take?
I've got it down to 5 basic steps, and going into any one of these, I could probably talk for 25 minutes on, so I'll just give a broad overview based on the guidance that's emerged from both the CDC as well as the recent New York State interim guidance. But the first thing you want to do, the first step, isolate and quarantine confirmed employees. So New York State has some guidance about how that's to take place, but just some practical things you're going to want to do with that employee is you're going to want to provide them with information about leave they may be entitled to under the Families First Coronavirus Response Act or New York's paid quarantine leave, and give them a single point of contact. You're going to want to develop a contact tracing form in the workplace, because the New York State interim guidance has some very detailed guidance about the steps that an employer must take in terms of maintaining information. And that kind of leads into my second point, is that you're going to want to address and isolate employees working near an infected coworker. And the New York State guidance says that you must notify the local health department and Department of Health immediately upon being informed of any positive COVID-19 tests. You must cooperate with the local health department to trace all contacts in the workplace. And the guidance goes on to say that local health departments will implement monitoring and movement restrictions and some other guidelines about the tracing process that companies should have policies and certainly be familiar with. The third thing you're going to want to do is clean and disinfect your workplace. And the New York State guidance heavily relies on what the CDC has to say about this. And I won't get into all of the details, but there might be a situation, depending on how recent the employee's contact was with the workplace, where you might want to engage a commercial cleaning company to do a deep clean of the office. But there's a host of other considerations that come into play there. But you're going to want to have policies and procedures for how you're going to address with cleaning and disinfecting issues when an employee tests positive. And also be making sure that you're compliant with the CDC guidelines on that. The other thing is to notify your employees. That's recommended by the CDC. And I believe one of our next questions deals with the confidentiality issue, so I'll kind of save that. But you're going to want to let the employees know, tell them what steps you're taking, because you need to communicate with them that the employees, after this, they're going to be returning to a safe workplace. So if you've taken any type of steps with cleaning, you should let your employees know about it. And then finally, you might need to consider whether you need to notify any third parties. So for example, if your employee was in close contact with a client who came into the office that day. And so those are the 5 basic steps, but there's a lot of material both from the New York State interim guidance and from the CDC that employers need to be aware of and make sure that they're including as part of their workplace safety plan.
And just to go back to the face mask question, all of the phase 1 reopening guidance says the following: employers must provide employees with an acceptable face covering at no cost to the employee and have an adequate supply of coverings in case of replacement. Acceptable face coverings include, but are not limited to, cloth and surgical masks unless the nature of the work requires stricter PPE. So there is an expectation that although not prescribed when you have to wear it, that employers provide it. So just important for people listening to know. And it may be different in phase 2, the phase 2 industries, but at least for phase 1, that's what that says. So the next question is about what happens. And by the way, there's because we're running out of time, I'm gonna take my moderator executive privilege here and take some of the questions and wrap them up into this. So the question is, what if someone gets COVID-like symptoms in the workplace? But there are a couple of questions around what happens if an employee is feeling well but has a temperature when they enter the building. And can a contract employee be responsible for temperature testing, or must it be done by HR? So I think those are the ones that relate to that as I'm looking here.
Well, let me try to address those issues. All of what Joe has just outlined in terms of 5 basic things to do and to be aware are the same things that you need to do when you have someone who has COVID-like symptoms identified in the workplace. Even if there's 1 or 2 symptoms, not all the symptoms, you have to make a decision as to whether or not you're going to send that person home. And the way to start with that is to have a safety plan in place, know what you're going to do, know what you're going to look at, and immediately follow those written procedures. You have certain people trained in your office or in your work site facility to handle that. Those are the people who are the ones who have been trained and should be handling that issue. And I would err on the side of caution and send that person home immediately, even if they feel fine, but they are showing a temperature.
And in that case, are those people, if you send someone home, is your expectation, or must your expectation be that they quarantine, and then are they on that emergency paid leave at that point? Is that what happens?
The expectation would be that they would quarantine, but if they don't develop any additional symptoms within a set time period, in fact, there are different time periods, even though 14 days is the critical time period, there are fewer days, 5.5 days, that you can see whether or not something is developing, but you would have them quarantine for that time period. And then you have to look at who they've been exposed to, and you have to maintain that same level of confidentiality that Joe was talking about, but also taking the right steps to immediately disinfect the facility, and to make sure that those who have been working in close contact with that individual, even though they haven't been tested positive, but had symptoms only, that they have been advised that they have been exposed potentially to someone with COVID symptoms. And then you're going to have those individuals also quarantine for a certain amount of time. It's not always 14 days, but at that point, you might send that one person over for testing. So if that person tests negative and they just have a cold, for instance, then you are able to bring those people back into the workforce.
So can you compel someone, if you send them for a test, I may have asked this already, can you compel someone to disclose the results of that test with you?
You have to be able to disclose it to the health department.
Well, the health
And-
department will know, because
Right.
the guy comes in, he's got a temperature, you say you got to go get tested.
That's
So,
part,
what
you
happens?
cannot compel that person to disclose that information to you as the employer.
So you have no choice but to really quarantine them, right?
Right. Mhm. But generally speaking, people want to get back to work.
Yeah.
And they will work very hard and tell you that they are free of symptoms and they're able to work.
Okay.
And the biggest issue we see with this, and we've had several positives with clients, is the fear that develops in the
Yes.
other employees. So you have to be ready to handle that as well.
Well, actually, that's the next question. So that's a good segue about what information can or should employers share with their employees if a coworker tests positive for COVID-19. So Liz, are you going to walk us through that, or?
Sure, I can. I think it's really important to be transparent with your employees so that they are aware that this has happened. And typically the conversation we have is you've either had very close exposure if you're in the same confined area with someone, or you may have had some exposure if it's an employee that works on the other side of the building, as an example. And you don't point out who the employee is, obviously. We've even said to people in a setting where there are clients and customers coming in too, you've been exposed to someone. So we haven't even said it's an employee that you've been exposed to. And it's important. They may figure it out if you're a small entity and all of a sudden one person's not there and you only had 5 there. They may figure it out for themselves, but I would suggest being very transparent and honest and open with your employees and talking with them and talking through their fear as well. It really does come down to communication to keep them engaged and make sure that they feel safe in your workplace.
Excellent. Okay, we've got about 10 minutes left here, so I think maybe we should just pivot to some of these questions that are that people want answers to, if that's okay with you guys. So the last couple we'll answer and send out, but I think we want to get people's questions answered. So, and some of these I think you've already answered, so maybe we're a little unclear. But what if employees, 18 people have asked this question, what if employees that have been working remotely, not laid off or furloughed, do not want to physically return to the office or plant? So Liz, you want to take that, or who wants to take that?
I think you need to determine why they don't want to return. So are they telling you, I can't return because I'm ill myself now, or I have an ill family member I'm taking care of, or I have a childcare issue, or I have an underlying condition myself, and then you'll have that conversation, that interactive conversation that Ann talked about with a reasonable accommodation. Or is the reason I don't want to come back because I'm just fearful. So I think you have to determine the why first. And once you understand the why, then you have to have the appropriate conversation. If it truly is, I'm just afraid to come back, I really like working from home, then you can say, your position wasn't remote to start out with. We did this obviously based on the pandemic, and our culture is one of collaboration and teamwork, and we want to get back to that. So we're asking that you come back. I think you can, I want to say mandate, and that's kind of a strong word. I have a very nice conversation with the employee, and most times you can ascertain what the reason is, and you can get them to come back into your workplace. And if not, then they're taking a layoff at that point, and you can rehire if somebody's refusing. That doesn't have a valid reason.
This question is interesting because I've gotten this question a lot about one of the state's guidance is no unnecessary travel. And the question that we've gotten many times has been, well, what if that's fine when they're not doing business travel, but what if they take a vacation? Then what happens? And 16 people have asked this question. If an employee goes on vacation and flies to a destination, does he have to quarantine for 14 days after he returns or not?
I think that's part of, go ahead, Ann.
I'll take that because we had that in our own office. And what we did is adopted a policy that said that if you vacation or you go out on a business trip that you think is even essential, or it may even not be, you and you have stayed in a hotel or other similar type facility, then you will have to come back and self-quarantine for 14 days. We made it a policy, and I think as a result of that policy that we adopted early on, we have had we had a great outcome. No one has come down with COVID-19.
That's great. That's great. Liz, you want to add anything to that, or?
The policy is the important thing. I think you have to make those decisions as a business. I know some of our clients have decided not to mandate that, or to mandate it depending on where the person traveled to. So someone traveling to internationally would be treated different than someone traveling to North or South Carolina, as an example. So, but your policy has to really dictate that.
So during screening, an employee positively responds to a question that indicates self-quarantine and are sent home. Are they to be paid for those 14 days? So I'm assuming during the screening process, they have either say they've been symptoms or contact with someone or whatever, and you decide to send them home. Do they have to be paid for those 14 days? And I do think that well, I'll let you guys answer that question. Liz, or Ann, or whoever.
Well, I'll take it. You have to pay the person that you sent home for the time that they worked in the office. If they are an exempt employee, you have to pay them for that day, and you have to pay them for the rest of the week. And that's something that I think some people are not aware of, that non-exempt employees, you can pay them by the hour, but you can't treat an exempt employee the same way. And most employers will pay the individual for the 14 days, or allow them to use first their pay time off so that they're paid, and utilizing those benefits up. But otherwise you don't have to pay them for the 14 days.
Right.
For the balance of the 14 days.
Just one thing to add, you're also going to want to evaluate whether or not the employee is entitled to leave under this New York State
Right.
quarantine law or the federal law, and that depending on the eligibility requirements and other factors, for example, for the New York State law, whether or not they have some order from a healthcare agency mandating that they be quarantined. So it's going to come into as to whether they're entitled to pay. You're going to have to look to federal and state law. Just a host of eligibility issues and other factors that you need to consider, but it sounds like it could be very likely in that situation, but the good lawyerly answer, it depends.
Yeah, and again, it comes back to that basic question of why, and taking a look at what analyses that you have to engage in to get to the end result.
This is a really interesting question that 10 people voted for. Should employers be doing anything additional regarding employees who are minors? Do we need to get parent permission to proceed with screening, parent sign off, or a liability waiver, etc.? Liz, you have any thoughts on that?
To my knowledge, you wouldn't have to do anything extra based on the fact that they're an employee. And typically if you had, let's say you had another disciplinary type of a situation with the employee, you wouldn't involve the parent, but maybe there is something legally that I'm not aware of, but to my knowledge, I would treat them the same.
Ann, or Joe?
That's right, because under New York workers' compensation law, you can't, it's the exclusive remedy for any type of workplace injury. So to the extent an employee has some type of claim about liability for exposure to COVID-19, they can't sign away their rights under New York State workers' compensation law. So I don't think a waiver would really be applicable in that situation.
So we only have time for a couple quick questions. So I want to ask this one first. I'm not sure myself to answer this question. Can we make an employee who has symptoms get a COVID test?
I think you can request them to get a COVID test. You absolutely can make them not be in your workplace. You can send them home 100%. and you should send them home, and that should be part of your policy. I don't think you can make someone take a test, but you certainly could make them have a 14-day quarantine, not come back to your workplace, and you could require them to have a doctor's note to return to your workplace stating that they are, fever-free for more than 72 hours and don't have any other symptoms. I think I would go that route.
Okay. Are essential businesses required to adhere to all guidelines, or are there any exceptions?
My understanding is that Empire State Development Corp recently issued frequently asked questions that you can find on their page. And my recollection is that the answer to that is that even essential businesses have to comply with the interim guidance. But you might
I haven't seen any exceptions granted. I mean, I think they've been a little bit specific about industry by industry what the requirements are, but I haven't seen any. You can apply for a exception or something. I haven't seen any of that.
Yeah, and I think that's pretty clearly stated in the Empire State Development Guidance.
Okay. Again, a question I think we've answered, but it's being asked again. What happens when an employee is not able to return to the office immediately due to no longer having childcare?
Yeah, they may qualify if they can't work remotely. They may qualify under the Emergency Family Medical Leave Expansion Act for 12 weeks of leave.
Last question, I think. Yes, last question. Oh wait, I'm getting an update from my back office here. Phase 1 guidance applies to all essential businesses that were allowed to remain open and ones now businesses who are cleared to be open. Thank you, Grant, for that. Okay. Now I gotta get back to I apologize here. Last question. Are many companies setting up a protocol asking their staff to take their own temperature at home before coming to the office?
Yes, that's clearly one of the ways that's outlined by the CDC. The CDC has basically there are 3 methods you can use for taking temperatures, including having your employees take their own temperature before coming to the office, or maybe providing a thermometer for them to take their temperature. And that's one method to kind of protect whoever's doing the screening, so that they can have less interaction with that individual. The downside is, you lose a little bit of control over the accuracy and reliability, but that is a common way that employers are using to screen employees, is having them take their own temperature.
Well, this is, you guys are great, and this has been a great session. I've learned so much myself. We still have 27 open questions, so we will try to get some responses back to people through the partnership or through our partners who are here on the call. But I do want to thank you, Liz and Ann and Joe, for really being great at really taking on these tough questions, and we appreciate your support and your support of the community and donating your time to help these other businesses out. So thank you all for being here, and we'll see you again soon. A little commercial. We are going to be doing a session, a couple more sessions coming up around reopening. So check our Eventbrite calendar so you don't miss anything. And of course, we're here to help you in any way we can at the partnership. So thank you so much for your time today, and have a great day. Take care.
Thank you.